2, 3. Testing Justice 1. Testing Justice Lopez. Testing 1, 2, 3. So that's coming through. All right. Testing Justice Lawrence. Testing Justice Lawrence. Testing 1, 2, 3. Oh, I can hear myself. Testing Justice Lawrence. Testing Justice Mead. Testing Justice Mead. 1, 2, 3.
Actually, that can make a huge difference.
Testing Justice Stanfill. Testing Justice Stanfill. Testing Justice Connors. Testing Justice Connors. Testing Justice Douglas.
We're happy to be here. Normally at this time, I immediately call the first case, but I'm going to take a few minutes to introduce ourselves and what we're doing here. I'm Chief Justice Stanfill. I'm the Chief Justice of the Maine Supreme Judicial Court. What that means is I am actually the head of the third branch of government. So you have your governor, you have your legislature, then you have your judicial branch. And we are the third branch of government, independent of the other branches. We love coming out to the high school, so thank you for having us here today. And I'm going to say a few thanks to some of the people who made this possible for us and some people who are here that should be introduced. First, welcome to Representative Greenwood, who is here, seated in the front row, and he was the one who invited us here today. And I understand Ms. Camire is here and has been instrumental in arranging everything for us. Welcome as well to Ms. Russell, the school board chair, I believe is here. There she is in the back. We have, I think, the lawyer of the day who is helping us, Adam Mooney, over here, who is an alum, I understand, of Oak Hill. The principal, Mr. Springer, here somewhere. There we go in the back. Thank you for having us. And always, thank you to the custodial staff, the AV staff, the setup, and everybody who's here. Sometimes these arguments are a little hard to follow, so hopefully you got some prep time in it because we compress an awful lot into a very short period of time, watching our lights go on and off. As I said, I'm the Chief Justice. My chambers are in Augusta. And because I'm the chief, I'm considered the most senior, but we have a ritual that we all do everything in order by seniority. So I'm going to turn it over to the Senior Associate Justice for him to introduce himself.
Thank you, Chief. My name is Andrew Mead. I'm the Senior Associate Justice. I've been a judge for 35 years. I served on the District Court, the Superior Court, and for the last 18 years on the Maine Supreme Judicial Court. My chambers are based in Bangor, and delighted to be here today. Made it through the monsoon. I'm still a little damp, but happy nonetheless. Thanks for having
Rain
us.
we desperately need.
Yes, no, not complaining about the rain. Happy to be here.
I am Catherine Connors. I have been on the bench since February 2020. I am the only one of these folks who was never a trial judge. I went from private practice straight to being an appellate judge. And I sit in Portland, my chamber's there, but I live in Kennebuck.
Good morning, I'm Rick Lawrence, and also very happy to be here. Thank you for inviting us. I have been on the bench for 25 years. 23 of those years were spent on the District Court, and in 2022 I was elevated to the Supreme Judicial Court. My chambers are in Portland, and I also live in Portland.
Good morning. I'm Wayne Douglas. Thank you for having us here. It's a pleasure to be here and see all of you today. I also have served on the trial courts, and for those of you who don't know, there are 3 levels of courts in Maine. There's a district court, a superior court, both of those are trial courts, and then this court, the Supreme Court. And I've been privileged to serve on all 3. I started out at the district court, I was on the superior court, and now I'm here. My chambers are in Portland, and I live in York County. Thank you again for having us.
And good morning. My name is Julia Lopez. I am the most junior justice, perhaps in more ways than one, but hey.
Oh.
Sorry.
I
couldn't resist.
How quickly they turn.
I have been on the Supreme Judicial Court just since the end of March, so I'm relatively new to this position. I previously was on the Superior Court, so one of the trial courts, and my chambers are in Portland, and I also live in Cumberland County, and it's a real pleasure to be here.
As you may have figured out, seniority does not mean how old we are. It means how long we've been on the bench, but apparently those two have come together in our most junior justice. I didn't mention it, I also was on this district court for many years, as well as on the Superior Court before being here on the Maine Supreme Judicial Court. So with that, we're going to turn to the first case that we have here this morning. The matter before the court is Androscoggin 24518, State of Maine versus Jennilee McNeil. I see counsel are present. I'm assuming they are ready to proceed. I would ask that each of you introduce yourselves by saying your names for the record, together with the party you represent.
I've been told this microphone is a very short reach, so pardon me. All right. Does this work correctly?
It works for me.
Fantastic. Good morning, Honorable Justices of the Supreme Judicial Court of Maine. My name is Attorney Andrew Emerson from the Law Office of Allen Labozo, and I represent the appellant in this case, Ms. Jennilee McNeil.
Thank you. And for the state.
Good morning. My name is Pat Mader. I'm an assistant district attorney, and I represent the state of Maine.
Thank you. And I didn't mention we are being streamed live on the web, both by audio and video. Attorney Emerson, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Thank you, Your Honor. This case involves a motor vehicle stop of a vehicle that was operating, depending on how you define the term, within their lane. And that's simply the question before the court today. It's a question that the Maine statutes are silent on. What is a boundary line? This case is remarkably similar to a case that Your Honors mostly all heard last year in Christopher Ray. In that case, Justice Lawrence, you asked the very pointed question, what is a boundary line? The state was unable to provide an answer in that case. They were unable to provide an answer in this case. The nearest metaphor, Your Honor, and I think we can look to sports, which is I see a very clear definition difference between the sport we play and what the impact of a line is. Either we have, as we outlined in our brief, the sort of hockey or tennis example, where just the briefest of crossing the plane, the touching of a line, is enough to constitute a goal or an out. But in the alternative, we have hockey, where you have to fully cross the plane in order for that to count in that definition. Just on its face, Your Honor, the statute is ambiguous because it's very clearly subject to very differing interpretations. At the motion to suppress hearing, Trooper Bordelais was very clear that if you include the painted line markers, my client was maintaining her lane. And if she was maintaining her lane, there's not reasonable articulable suspicion that there has been a traffic infraction, and therefore no basis for the stop. Trooper Bordelais describes that there were simply no other factors that led to his stop. His stop was very narrow, simply on the 1 minute and 30-second observation, 90 seconds, wherein the vehicle driven by my client moved from the fog line, contacting but not crossing, and then within 1 minute and 30 seconds, in a consistent motion, Trooper Bordelais' own words, moved over towards the center line, towards but not crossing, and making contact. Based on that motion, which he described as a consistent motion, not erratic, not weaving or bobbing, and maintaining within the lane if you include the paint.
Counsel, I see that the green light is on. In this case, the question is whether there's reasonable articulable suspicion for the stop, correct?
Correct, Your Honor.
That can be based on a violation of law, such as not staying in your lane, or it can be based on simply the summary of the facts that are observed that lend the officer to have reasonable articulable suspicion that a violation or crime is being committed, right?
Correct, Your Honor.
So below, the judge didn't address the issue that you just raised, which is whether there was technically a violation of the statute. The judge really denied the motion and said there was suspicion based on the totality of the facts.
Certainly, Your Honor. I think
Can't we just address it on that issue without deciding what the boundary is, what it means to stay in your lane for the civil infraction, and simply look at and this is on a video, by the way, right?
it is, Your Honor. And I think the video
look
is...
at the video and see what's going on and whether that would amount to reasonable articulable suspicion on the totality of the facts.
Yes, Your Honor. In fact, we encourage the court to look at the totality of the facts in this case because there was no other indicia of erratic operation or
Well,
impairment.
it's a little different than our previous case because we do have a video, and it shows 90 seconds of what some people would call weaving, back and forth within the lane. So why isn't it reasonable articulable suspicion that the person is either impaired or distracted? It's not like the previous case where there was one little jog. There's 90 seconds that he's watching, going back and forth. Why isn't that reasonable articulable suspicion? It's not probable cause. It's just reasonable articulable suspicion.
Something more than a hunch.
Yes.
Certainly.
Why isn't that enough?
Certainly, because in this case, Your Honor, the articulable suspicion mentioned by the officer is simply the failure to maintain a lane. That's his own observation.
Can I challenge you on that? You've said the issue in your brief. You say the sole reason articulated for stopping the defendant's vehicle was for making contact with but not crossing over the marked line. You say that's the sole reason, but as we look back at the officer's testimony, and as also cited by the court, he says, what you see here is the operator of the vehicle weaving within the line, almost crossing the fog line, not crossing the fog line. And we also have the court making a conclusion that she was bouncing, kind of swerving between the lines. So it really wasn't the sole reason whether it crossed the line. That was a reason, which if it was the sole reason, you would win. But both the court and the testimony make reference to weaving and bouncing.
Understood, Your Honor. And I think the appellant would characterize the movement of moving within your lane as normal operation. If there was, he never uses the word erratic, and I think that's where some of the other case law is distinguishable, where you have an operator who's aggressively swerving. And I think the language.
Let me just ask you hypothetically, you're driving behind another vehicle, and they're fishtailing, they're going like this. They're not hitting any white lines. You don't think that would be articulable suspicion? It's not this case, but hypothetically.
And that would be, absolutely, Your Honor. And it's very telling that the officer makes no observation about the defendant's speed being concerning, no observation about the time of day, no other observation but the intra-lane movement if you include the
So
paint.
this is on video. There's a video cam from the cruiser. We can see the video just as well as the trial court. What do we do with that?
I think watch it very carefully, Your Honor, and see that there is not any swerving or weaving.
Or see that there is weaving?
I think the officer's testimony who was at the suppression hearing is very telling. He doesn't describe it as erratic. He's the one making that observation on the scene.
Counsel, the question is what an objectively reasonable officer would find under the circumstances, right? So can't we look at the video combined with the officer's testimony and make an assessment as to whether the trial court's judgment about reasonable articulable suspicion was right? We're not confined to the way the officer described it in testimony, are we?
No, Your Honor, but I think, again, that's back to Chief Justice Stanfield's point. The video sort of speaks for itself as far as it goes. The operation is not pronounced, erratic, causing endangerment to other moving vehicles. In fact,
it's weaving, as Justice Connor said, for about 90 seconds. So this is not once. It's sort of back and forth, back and forth. Why is that not an objectively reasonable basis to think maybe this person isn't there?
well, Your Honor, I would point both to the court's jurisprudence in Cairn, which indicates that when there is just a brief one-time contact, and in that case,
More than one time, counsel. That's your problem.
Absolutely.
Again, to repeat, for 90 seconds, there is this going back and forth within the lane. Let me just ask this. Don't you have another problem from the standpoint of, obviously, you apparently disagree with the characterization that the trial judge made, having heard the testimony and seeing the video. You never filed a motion for further findings of fact. Is that problematic from the standpoint of our review of this matter?
It's not, Your Honor, which is why we encourage the state to review the matter de novo as a matter of statutory interpretation, and it can also be clearly erroneous as a matter of law.
But
If
the statute was not what the judge below relied on, nor do we need to rely. When you say a matter of statutory interpretation, the judge below did not find or even address the issue of whether there was a violation of the statute that requires you to stay in your lane. The decision below is based on an observation of facts that, taken together, lead an objectively reasonable to believe that this person may be distracted or impaired.
And on that point, the trial judge made findings. Isn't our job to say whether there's evidence in the record to support those findings? We don't independently find the facts, do we?
correct, Your Honor, and there's
And doesn't the video and the testimony combined support the trial judge's findings?
It does not in this case, Your Honor, because
Why not?
and there was no need for a specific finding of further facts, as the trial judge or the hearing judge made very clear what the basis for her upholding the stop was, as quoted in
The vehicle was weaving for 1.5 minutes, and that's sufficient.
that it was the intra-lane movement of up to but not approaching the fog line, and up to.
And the court said it could reasonable articulable suspicion of criminal conduct, civil violation, or a threat to public safety. So the court was saying, I'm looking at that video, I'm seeing this weaving going on for 90 seconds, and I think that there's enough for the policeman to say, hey, this is unsafe. It's not necessarily a violation of any statute. Isn't that enough to stop the vehicle?
No, Your Honor. First, because we would argue it's not a violation of actually failing to maintain a lane, as the statute is ambiguous on that side. And to answer Justice Lawrence's question, I believe, on this note, where Karen, we don't necessarily have as even egregious a conduct as in Karen, where in that instance there was a fully crossing over of the center line, posing a public safety danger. In this case, simply contacting the paint.
But does it matter that it was more than once? In other words, if granted, if a vehicle drifted from the fog line toward the, I think it was called the skip line, because we're on the turnpike in this case, once, that might be different than if they do it back and forth, back and forth, back and forth 20 times. It didn't happen 20 times in this case, but there's a continuum there, right?
Certainly, and I think that's probably a good word to use, Your Honor, because this court in LaForge very carefully draws that distinction between Karen not setting out a numerical test for the number of contacts with traffic control lines that could give rise to reasonable articulable suspicion.
You know,
So,
you've teed up an issue here that I'd like you to address. I'll ask both counsel to address. You said at one point, watch the video, meaning us, watch the video. And this is a case where the trial judge looked at a video, made certain conclusions. Can we, as the appeals judge, look at it and go, whoa, I'm not seeing that there, and make a different finding of facts, so we would be reviewing the evidence de novo as opposed to reviewing it. See what I'm saying here? Can we do that?
understood, Your Honor. The trial court's determination can be there's certainly deference in our
We have
case
to give
law.
deference to what the
Correct.
trial judge.
But if they're clearly erroneous, Your Honor, and I think we have in this case a clearly erroneous finding where there wasn't a need for specific findings because the trial just outlined them on
Only be
page.
clearly erroneous if we, in our opinion, in our view, thought, I don't see it there. So then we said, okay, Judge Jones, you saw it this way, we see it this way, and our finding of fact overrides. Isn't that problematic? Doesn't that sort of shift the whole appellate view?
It does not, Your Honor, because the determination, the specific facts that the trial judge put on the record in pages 40 and 41 of the trial transcript show that it is the weaving within the lane, the intra-lane movement is the sole basis that she articulates for the stop. And this court can find, as a matter of law, that is erroneous. As we outlined in our brief, multiple other states have made that determination, that simply intra-lane movement. If you include the paint or not include the paint, that intra-lane movement.
Doesn't it depend on the facts of the case? And isn't every case different?
Absolutely, Your Honor.
And how can, as you pointed out, the court found that the vehicle was going from one side of the lane to the other side of the lane, back again, back again, back again, back again for a period of 90 seconds.
And I note
Correct.
that the yellow light will remain on for 60 seconds,
Yeah.
so it's pretty long.
So, I mean, isn't that, she found that was weaving, those kinds of movements. Doesn't the record support those findings? And can we say, as a matter of law, that's not?
Yes, Your Honor. Under State v. Sylvain, whether an officer's suspicion is objectively reasonable is a pure question of law. And in this case, the intra-lane movement, as other states have found, can, for various policy reasons, be very problematically eroding the standard of reasonable articulable doubt, a reasonable articulable suspicion to essentially meaningless standard. Any contact, even brief.
Was the officer or the court that said, there's really only two reasons that somebody would be doing that. One is they're impaired, or the other is they're distracted.
Or perhaps the roadway turned and she continued to maintain a straight line of travel. As the video shows, the highway was approaching a bend as she went from riding the fog line to approaching the center skip line. There's a number of, the alignment of the vehicle could be out of whack. There could be a fly in the car. There could be any number of.
Alignment out of whack, can be a safety issue.
I see my time's expired, Your Honor, if I can essentially, it's the type of driving conduct that is so common and innocuously explained that in order to justify reasonable articulable suspicion, there simply needs to be plus, something else to justify the stop.
Thank you, counsel. You reserve some time, I believe, for rebuttal, so you'll have that opportunity. Attorney Mader?
And you have the green light right from the get-go, right?
I do.
How do you respond to the comment that this was common and innocuous? So if you could get stopped for this, anybody can get stopped at any time.
I would suggest that if it is common and innocuous, we have many people driving on the highway who are putting all of us at risk. If you review the testimony of Trooper Bordelais, he told the court that he patrols the Maine Turnpike. It's a 109-mile stretch of road from the New Hampshire border to just south of Augusta. That's what he does. And he described on page 7 of the transcript, he described what he looks for. The lines are important. Traffic on the Maine Turnpike in the section where this occurred is at 70 miles per hour. That is 102.6 feet per second. That means every car is traversing a football field every 3 seconds. This is a high-speed motorway in which things can change quickly. He is paying attention to oddities in the driving behavior. He is watching for lines. He is watching for people who are encroaching upon the lines because it is his responsibility to make sure the highway is safe. And he was able to clearly describe for the trial court exactly why he stopped this vehicle.
But most of us are not so skilled as to precisely maintain a distance from whether it's the fog line or the skip line, right? I mean, we move in the lanes.
But he added, he said that he watched the vehicle for a period of time, and if you refer to page 12 of the transcript, he said, I watched it for a while because I wanted to make sure it wasn't, in his words, a one-off, like they had dropped a phone or they were changing a radio station. For 90 seconds, as the trial court found, this vehicle...
Was the trooper's testimony even a factor here when the court had the video? The court saw what the officer saw.
The video recorded...
And we have the video.
The video recorded...
That's my next question.
It was admitted into evidence. The video recorded the officer's observations. The officer's explanation as to those observations is important because as all of us have different training in different areas, this law enforcement officer is trained in the investigation and the enforcement of Maine's traffic laws. So when he sees something on the highway that someone who isn't trained in that area might say, not a big deal, he focused in on this vehicle because it was operating in a way that was distinguishedly different from every other vehicle he had seen that day. This vehicle caught his attention. He followed that vehicle. He was watching that vehicle.
Let me do my follow-up question that I was sort of teeing up here. We have the video too. We've seen it. We've watched the video. And what if, just hypothetically, what if we looked at it? Well, it's no big deal. I see people, I probably drive like this myself. I might be listening to the radio or something, but I don't really see the weaving there. Would we have the prerogative to say that the trial judge got it wrong when she saw weaving?
I would suggest, Your Honor, that if you refer to page 10 of my brief, the standard of review is outlined. The standard of review by this court is whether the record on appeal establishes that the findings of the most injustice are clearly erroneous. This court reviews the legal conclusions of the court on a motion to suppress de novo, although the law court reviews historical facts, and I would suggest those are the factual findings made by the court, as well as the other evidence in support of those factual findings, differentially.
What if
So-
all you did was put on the video and didn't bother with testimony other than authenticating that this is the video from the cruiser cam? Would that be a different situation where we're seeing the same video as the trial judge?
That would be a failure of effective prosecution in my mind, Your Honor. I would.
That aside, and Attorney Mader, I know you would never do that, but
I would suggest, Your Honor, you can look at the video, but putting the video in context. We can see things on the video, but just understanding the context of what that means and understanding why this trained law enforcement officer was paying particular attention is important. This officer is able to articulate. He was able to describe for the court below exactly what about the operation of that vehicle caused him to be concerned. He didn't know, are we having a medical issue here? Do we have a distracted driver? Do we have someone who's under the influence? He simply didn't know. He just knew at that point in time this vehicle was being operated in a manner that was distinctly different from
Well,
other...
Let's say, take this hypothetical, distinctly different. It's the turnpike. It's 70 miles per hour top, and then there's usually a minimum speed of 55.
55 is the minimum speed.
All right, so the policeman is behind somebody who's going 56 miles per hour. Not many people go 56 miles per hour. So after 90 seconds, does he have reasonable articulable suspicion to stop that car?
If that vehicle, if he can articulate what about 56 miles per hour distinguishes this vehicle from every other vehicle, and is there a safety concern?
I was going to say,
Is there a
it's not just
mechan-
distinguishing. There has to be a reason to think that there may be a safety concern of an offense being committed, et cetera.
And that is where the officer's judgment and training comes into play. The officer interprets those facts. The officer makes the observations and then interprets based on his training and experience, what do those observations mean to me? And in this particular case, this highly trained law enforcement officer who has patrolled the Maine Turnpike for the entirety of his Maine State Police career and followed this vehicle for a period of time, and there was 90 seconds of observable conduct that he was able to describe as a safety concern.
You address, though, the argument that Attorney Emerson is making, that by definition, this was not a violation. In other words, that she did not cross out of the lane, even if the tires may have hit the fog line or the skip line. She remained in her lane. It was therefore not a civil violation. Therefore, it's not an appropriate stop.
The reasonable articulable suspicion of stop does not end at traffic violations or criminal matters. There can be safety concerns.
Was there a traffic violation?
There
here?
can be safety concerns.
Was there a traffic violation here?
I
You're
don't.
just saying it doesn't matter.
I'm saying it doesn't matter. I am saying that the
You
line.
don't want to address whether it really was or wasn't.
Well, I was somewhat impressed by the reference to the sports analogies, and as this court may know, I'm an NCAA volleyball official, so I do pay attention to lines, okay? And in the game of volleyball, the line is in. Any portion of that ball touching any portion of that line, that ball is in. And I pay attention to lines a
I'm a
lot.
hockey player, and the puck has to cross the line to
right,
go
well,
in, and I know that.
All right,
I've done it so many times.
and I know the volleyball lines.
But
And this
fouls
trooper
can
knows
be-
the lines on the turnpike.
But fouls can be committed within bounds.
Oh, absolutely. Absolutely. Fouls can be committed in bounds. That ball can be touched before it goes out of bounds, and the team touching the ball is the one who's going to be at fault, and the point's going to
Well,
go to
under
the other
standard
side.
that applies here, the officer also gets the benefit, does he not, in the circumstance of reasonable articulable suspicion, either a crime or a civil violation or a safety issue has occurred, is about to, or is in process of occurring, or may occur. So to the extent that his training is brought to bear, in circumstances, as long as he articulates something that would lead him to believe that there could be a violation, isn't that sufficient?
It is, Your Honor. This court has said that on many occasions, and this officer went the extra step. If you look at his testimony on page 12, he said, I followed the vehicle because I wanted to make sure it wasn't, as I said before, in his terms, a one-off. Did that person change the radio station? Did that person drop something? Were they trying to fix something else in the car that could have explained that momentary deviation from operating clearly within your lane? This person operated in the manner that the officer described, in the manner that is visible on the video, for 90 seconds at a
What is-
speed limit of 70 miles per hour.
What is the line, counsel? And I imagine you're probably going to say we don't need to draw the line in this case, but we have 90 seconds here. We have multiple instances of weaving. We have, I think it's Karen, where there's only one, not enough. Where would you say the line is, where it's normal operation as opposed to suspicion of something else going on?
I would say that is a case-by-case determination that all courts will have to wrestle with when the facts are presented to them.
Is
And
this close to the line in your view, or you think this is
I-
clearly past it?
I think in this case, it is very clear that this officer, based on his training and his experience and his explanation and interpretation of what he saw, had reasonable articulable suspicion to stop the defendant's vehicle to investigate why is there an apparent issue with her ability to maintain that vehicle within her lane without weaving.
But there could be a totally innocuous reason. I mean, she's bopping along. I mean, maybe she's listening to the latest Taylor Swift, and therefore she's kind of dancing. It's not illegal to do that, is it?
It is not, but the issue here is reasonable articulable suspicion to stop. If he stopped the vehicle and she said, hey, I had my headphones on and I got lost in the music, okay, goodbye. But in this case, there was more once she was stopped. He determined that she, in fact, was under the influence.
Was the trooper offered as an expert witness?
He
Yeah,
was,
as we know, an expert witness can testify to opinions because they have knowledge that we don't have as members of the public.
I don't think he was specifically designated as an expert in the transcript, but he certainly did testify based on his training and experience.
And your argument today is that we should put special emphasis on his testimony because of that, which sort of sounds like expert testimony.
It sounds like expert testimony, and it is his interpretation of what we all may watch on that video. It may mean something different to all of us,
So if we
but
watched it and we didn't see anything that concerned us, but we don't have training or background, but he, as an expert, as a trooper, has training and background, so we defer to him?
that's why when I presented the case, I offered his interpretation. I may not know if that hockey puck went over the blue line or not. I'm going to defer to the referee. And in this instance, we have a trained trooper who has clearly defined why he stopped that vehicle. And I would suggest that based on the record in this case, there's simply no basis for this court to overturn the findings made by the suppression justice.
Thank you, counsel.
Thank you.
I know your yellow light didn't go on. We didn't get to count 60 seconds again. And Attorney Emerson, I understand you reserved 2 minutes.
I have,
That's
Your Honor.
120 seconds.
So slightly more time than Trooper Bordelais. I had to observe two touching of contact with but not crossing over lines over 90 seconds, as the state indicated, traveling at a football field every 3 seconds. That is not weaving. As the officer described, if we're to give any due deference to his testimony, it is that he described it as a consistent motion, not erratic, not posing a public safety concern whatsoever by his own testimony. By his own testimony, there's nothing more than the contact with but not crossing over the traffic control.
If you were behind a tractor-trailer truck doing the exact same thing, would you think that would be problematic?
Absolutely not, Your Honor. In fact, Miss McNeil was, in fact, behind a tractor trailer, as we saw in the video, and she
But
successfully...
the tractor-trailer wasn't going back and forth within the lane.
No, Your Honor, but if we observe in the totality of the circumstances, as the court should, she successfully used her indicators, smoothly changed lanes, overtook that tractor trailer, indicated once again, smoothly changed lane, all indicia of non-impaired successful operation. In the totality of the circumstances, not only is there not something more as far as other traffic violations, the circumstances show she was operating safely, and the de minimis contact, combination with the length of time, simply does not constitute erratic operation and weaving.
Do we take into account how close she was to the skip line when she actually stopped her vehicle?
I don't quite understand, Your Honor. I apologize.
Fog line.
Fog line, sorry. Do we take into account how close she was to the fog line when she stopped her vehicle?
No, Your Honor, because I think at that point the officer had already determined he had enough reasonable articulable suspicion to instigate a motor vehicle stop. So the timing that we're really looking at is that first 90 seconds of observation, which is, in his own words, 2 to 3 contacts with but not crossing over the lane lines in a consistent motion. Not erratic, not weaving, not bobbing. The intra-lane movement, as the state indicated, is not illegal and should not be the standard that this court imposes in contravention to LaForge and to Karen, that de minimis, explicable, innocuous, potentially explicable contact with the traffic control lanes is reasonable enough suspicion for the officer to...
I think we should take this moment to recognize the historic nature of his argument. It is, to my knowledge, the first time that the NFL and NHL rule books have been cited as authority to the highest court of the state. So
The MLB as well, Your Honor.
Don't forget volleyball.
Yes, volleyball. Thank you, counsel. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. We don't give our decision as we sit here today. I will take this moment to recognize Attorney Emerson. I understand this is your first appearance in front of this court.
Yes, Your Honor.
Welcome. Ordinarily, when we are in our courthouse, we invite you back to have the greetings of the court in person, but here I'm afraid we're not going to do that. So I'm just acknowledging it here in the open.
Thank you, Your Honor. I think
Welcome.
it's encouraging to do some more appellate work.
Always happy to have appellate our attorneys. And with that, we'll be in recess on this matter.
All rise.
And good morning, you can be seated. We're told we have to swallow our mics. Good morning. I know that some of the students have changed, so I'm just going to briefly start again. I'm Chief Justice Stanfield of the Maine Supreme Judicial Court. The judicial branch is the third branch of government, for those of you who have actually gone to school and learned these things. And as the Chief Justice, I am essentially the head of the third branch of government, just like the governor is the head of the executive branch. We are here this morning because we love to go out to schools, and we hope this is at least somewhat informative, maybe even potentially entertaining. I think the last one was actually fairly entertaining. And here this morning. As I say, I'm the Chief Justice. My chambers are in Augusta. And before I was on the Maine Supreme Judicial Court, I also was a trial judge for many years. We always operate in terms of seniority. And because I'm chief, I'm automatically considered senior, and by that we mean terms of service, not the oldest, to be clear. We'll let you guess who is. So I'm going to let the other justices introduce themselves, starting with the senior associate justice.
Good morning. My name's Andrew Mead. I'm a senior associate justice. I've been a judge for 35 years. I served on the district court and superior court, and for the last 18 years been on the Supreme Judicial Court. My chambers are based in Bangor. We typically do arguments in Portland, Augusta, and sometimes Bangor. Great to be here today. We made it safely through the monsoon, and happy to be with you.
I'm Catherine Connors. I have been on the bench since February 2020, and unlike my colleagues, I was never a trial judge. I came right from private practice, so I have never told anybody they were overruled.
Good morning. I'm Rick Lawrence. I have been on the bench for 25 years. 22 of those were spent on the district court bench, and then I joined the Supreme Court in May of 2022. My chambers are in Portland, and I reside here. So happy to be here.
Good morning. I'm Wayne Douglas. It's a pleasure to be here. Thank you for having us. I have been a judge for a little over 20 years. I served most of that time on the trial court, and I've been on this court for about 2.5 years, and my chambers are in Portland.
And good morning. My name is Julia Lopez. I am the newest member of the court. I joined at the end of March. I previously was a trial court justice on the Superior Court, and my chambers are in Portland as well. And it's wonderful to see you all here this morning.
And today, this time you're not rubbing it in that you are junior in more than one way.
I already made the joke once.
Okay.
Which was more than enough.
This is more than enough, yes. And I also wanted to mention, I think Ms. Whalen from the school board has joined us here today, somewhere. There we go. Welcome. Thank you for having us here. With that, then, I will call the first case. The first matter that we have is Cumberland 24-479, Larry Anderson versus the Department of Marine Resources. I see counsel are present, and I assume ready to proceed. If you would introduce yourselves simply by saying your names for the record, together with the party you represent.
Nicholas Walsh for the appendant, Larry Anderson, Your Honor.
Assistant Attorney General Valerie Wright for the Maine Department of Marine Resources.
Thank you. And we are being streamed on the web, both by audio and by video. And Attorney Walsh, if you're ready to proceed, we'd be happy to hear your argument here this morning.
Okay. May it please the court. I represent Larry Anderson. Mr. Anderson is a lobsterman who fished out of Harpswell. In October of 2023, the Maine Department of Marine Resources suspended his license for 3 years, asserting that he fished more than 800 traps and that some of those traps were untagged. DMR reached this decision after an administrative hearing with no jury. Mr. Anderson moved for and was denied a motion for jury trial. This court has long held that a person's right to engage in an enterprise is a property right granted by the state in which that person has a property interest. Article 1, Section 20 of the Maine Constitution provides that in controversies concerning property, either party may elect a jury trial. Therefore, it was error for the administrative body not to leave this matter to the courts where Mr. Anderson could get a jury. The Superior Court on our Rule 80C appeal seemed to assert that Mr. Anderson did not have a property interest in his license because, as I understood the opinion, the license could be suspended at the discretion of the commissioner. That is error. It's false. The only reason that Mr. Anderson's license could be suspended would be on a finding of a violation of a marine resources statute, and that finding, per my argument, has to be reached after a jury trial if either party so elected. DMR seems to agree in its briefing with the position that a protected property right is at stake here, for the defense is that the suspension was equitable and that matters heard in equity, notwithstanding the Maine Constitution's language, matters heard in equity have not been afforded jury trials, a proposition with we do not disagree. But it's wrong. That argument is wrong on at least three reasons. First, equity acts only when the court is presented with unusual fact patterns on a repeated or single basis, requiring unusual remedies. Classic examples, of course.
The light is on. And I want to take you back to the text of Article 1, Section 20, which says, all controversies concerning property, the parties shall have a right to a trial by jury, except as in cases where it has heretofore been otherwise practiced. Our Constitution was adopted in 1820, so isn't the test for whether you get a jury, if you don't get a jury, if you didn't get a jury for that kind of case in 1820?
It is. No, you're correct, Your Honor, but fisheries cases in the colony and then in the state have always been heard before juries until 2017.
But isn't this regulation of a license?
It is and it isn't. It's a regulation of a license to engage in a trade. What the tradition, I mean, in Maine, the first lobster regulation didn't get enacted until 1878, but transgressions or violations of that statute have always been heard in courts until 2017, when the law was changed to allow for the administrative suspension. I beg your pardon?
Because they were criminal charges.
Because they were criminal charges, but then DMR, per its statute, used the result of the criminal court as the predicate for the suspension, correctly.
How many administrative suspensions challenged in courts happened back in 1820? There weren't a whole lot of administrative actions.
Well, there weren't. These cases have been inherently at law all the way along, since the 1600s.
But can you cite me to a case where somebody had a license administratively suspended and got a jury trial back in 1820?
Yeah. There's a drayage case cited in my brief out of Massachusetts.
And for the benefit of everybody here, drayage.
Drayage it still exists. We call it trucking now, and it was drayage is carrying cargo by dray by a heavy horse-drawn wagon. And in the case that I cited, a man was cited by the state of Massachusetts for engaging in drayage in Boston without a license, and his matter was heard before a jury.
Counsel, maybe I'm wrong about this. Wasn't that case also a criminal violation?
I don't believe it was criminal.
All right.
I mean, perhaps it was, but I don't think that's a distinction particularly matters. What matters is that the state was seeking to take away his license to engage in a trade, not a license to engage in law or to be a physician. Those are matters that were inherently policed by their own bodies.
When even though that may be one of the consequences, if it's also criminal, in other words, if there are other potential consequences, that becomes a different animal.
If
doesn't it?
it's cleaner, I would absolutely concede. It's cleaner if it's criminal.
And it's clear that in 1820 you could have a right to a jury in those cases.
The tradition has been for a right to a jury in criminal cases, but also in cases where a person's right to engage in a licensed trade was taken away.
Counsel, does that mean that in every instance where the state licenses doctors, nurses, all of those individuals have a right
No.
to a jury trial?
No,
Then how do
it
you
doesn't.
distinguish
There's
this case?
there's an easy, appropriate, and correct way to distinguish it. Well, first off, physicians and doctors have always policed themselves. So that's the inherently administrative matters that are spoken of in the case law concerning driver's licensing, for
Well,
example.
you can say they police themselves, but it is the executive branch that will suspend a license, et cetera.
But I'll go on. In addition, the right to engage as a physician or an accountant or a lawyer involves a public welfare implication. Public safety in the case of a physician, but public welfare in the case of others.
What about plumbers? What about electricians?
Those-
What about any of those professions?
If-
All of those all would require jury trials?
Absolutely, unless the Constitution of the state of Maine is amended.
Well, this is it. I mean, we're looking for what is the closest cause of action, if any, what is the right claim, in 1820. And do you agree that in 1820 there were cases in which there were challenges to governmental determinations, and you wanted judicial review of an executive branch determination, which is what this is?
That there were such cases?
There were some cases?
There must have been. I mean,
Well, how about Marbury versus Madison?
well, there's that.
And what was the cause of action that the people who didn't like the governmental action used in that?
Well, if memory
Mandamus,
serves.
writ of mandamus. There were writs of mandamus and writs of certiorari in 1820. And did you get a right to a jury for writs of mandamus?
No.
No, you did
And
not.
that's not what we're arguing.
Well, isn't
Well-
that the kind of what we're looking at?
Where's the
Tessing's
property right in
case?
that? I don't see it.
Well, the property right
I mean,
that
you-
you're
well,
talking about, that you're citing the Munjoy Sporting and Athletic Club, but that was a due process. That's an issue of, if we're going to suspend a license or something, then you have the right to have at least some process. You can't just do it arbitrarily, et cetera. Your client had process. I know you don't like the process, but your client had process. He had a hearing at DMR, right?
Held over Zoom, no rules of evidence? Yes.
He had a hearing, and he has the right to appeal that result to the Superior Court, which he did.
On errors of law.
And then on errors of law under an ADC appeal, and then from there to us. So
No jury trial.
no jury trial, but basic due process, which is notice and opportunity to be heard.
It was extremely diminished due process. It was due process. It was not the due process that Article I of the Maine Constitution guarantees them. There's no question that this court has a robust jurisprudence holding that a person has a property interest in a license to engage in a trade.
Counsel, can I take you back to my earlier question? Is your challenge here to the on the administrative level, or is it to the appeal under the ADC? Are you
Well,
saying that-
our appeal is from the ADC decision.
I understand, but are you saying that the right to the jury trial exists at the first stage?
Yes.
So that all of our administrative agencies that issue licenses and overview these professions and trades, every single one of those would be invalid if it involves property rights?
The legislature has dealt with this issue before and afforded, for example, in the FED cases, where this court held up a jury trial right exists to evictions, that the sort of initial screening is done at the district court level.
It's not just initial screening, the trial.
The
case is
trial,
done.
and then if the parties wish, they may invoke their right to a jury. I see something like that
So
occurring.
that would be an argument then that the jury trial should have come when you appealed to the Superior Court?
I mean, I'm not
You
the
agree
legislature, but it seems to me that's a reasonable approach.
I mean, DMR doesn't have the ability to give you a jury.
I get that, and I got that when I filed my motion. What I wanted them to do and suggested that they do in my motion was, look, there are presently pending a number of court actions concerning Mr. Anderson. That's where this matter should be adjudicated, just as it was from the mid-1600s until 2017.
So if there is no other pending action, and I'm an electrician, and I'm in the same boat as, so to speak, as your client, I can request from the agency a jury trial?
If I'm the Maine legislature.
No, you're not.
No, I'm not. But I promptly
So I'm
enact a
asking
law
you,
that says.
Is that, well, we deal with the law as we have it. So as it stands now, is that your argument, that the whatever bureau that is that governs electricians or plumbers has to provide either a jury trial or refer it to a court for a jury trial?
Correct. Absolutely.
That would
Because
be-
that's what the Constitution says.
Can I just take you back? I'm just trying to understand sort of a basic premise of your argument. Looking at Article 1, Section 20, you're very focused on the language controversies concerning property. That provision talks about in all civil suits. Is it your view that this is not a civil suit?
I think it is a civil suit. It's not a criminal action. It's something, is there a sort of third cause of action that's administrative? It seems to me it probably is civil.
Okay, so I'm just trying to understand why the focus on the controversies concerning property.
Because it's so clear. That's why. Because this court has a robust jurisprudence protecting property rights, and the Constitution guarantees the parties a right to a
Well,
jury
the
trial in those
jurisprudence
matters.
You cited us, as was discussed earlier, due process cases. The property interest cases that you've cited to us all have to do with the right to due process, which I think you've conceded, even though you didn't like the process, your client did receive due process. Is that fair?
You reserve process, and I suppose you could call it due. I don't think it was a very good process. But, they held hearings over Zoom during COVID, and then they decided it was so convenient, let's just do the whole thing by that.
We find most lawyers want to do it that way in
Well,
court.
it's a heck of a way to confront a witness, but it is convenient and it's easy to schedule. It's just a little rough on the person whose rights are being damaged.
Do you agree, counsel, that this is an ADC action, that in Maine, Rule 80B and 80C were designed to replace the writs that we were discussing earlier?
I think so.
Thank you.
Thank you.
Am I done?
You are, but I think you reserved 3 minutes for rebuttal,
did.
which
Thank
we'll
you.
give you. Attorney Wright.
Chief Justice Stanfill, may it please the court. This appeal of agency action may be decided based solely on the ample precedent in Maine law, holding that equitable claims do not implicate the right to a civil jury trial under Maine's Constitution. There can be no question that the Department of Marine Resources' administrative suspension of Mr. Anderson's lobster fishing license is equitable in nature. The only relief at issue is the agency's suspension of a lobster license that it had issued. There is no civil penalty, fine, or other monetary relief at stake. Moreover, in enacting the department's administrative suspension statute, the legislature expressly stated that such suspensions are remedial, not punitive. Because suspension of a license is remedial, no civil jury trial is available under Maine law. This court has held so numerous times in the context of driver's licenses, which it has compared to professional and occupational licenses. Massachusetts case law is in sync with Maine on this question, and that is worth noting because the Maine and Massachusetts rights to a civil jury trial are rooted in the same language in their constitutions. The Massachusetts Supreme Court has expressly held, for example, that doctors and lawyers may have their licenses suspended without a civil jury trial. The appellant, Mr. Anderson, contends that the financial impact of the loss of his lobster license renders the suspension of his license essentially a legal claim. But the case law is squarely against him on this point because it looks to the nature of the claim and the relief sought, not the collateral consequences that may flow from such relief, to determine whether a claim is equitable in nature. So simply put, the department's administrative suspension of Mr. Anderson's lobster license is equitable, and the department's decision should be upheld for this reason alone. I'm happy to take any questions that you may have.
Counsel, you keep focusing on legal versus equitable, but that is not the language of the Constitution, is it? It is that you have a right, and we have made clear, you have a right to have a jury trial on any claim in which you may have had that right in 1820. If the exact cause of action didn't exist, we look to find one that is similar and figure out whether you should have a jury. It's the opposite of the right under the federal Constitution. It's not, there says nothing about equity versus legal.
The Constitution itself does not, Justice Stanfill, but the case law interpreting that constitutional provision in a...
But is that, it may be a shorthand for some certain kinds of cases in equity. Obviously, you would not have had a jury even in 1820, but then you started talking about it's remedial. But so are damages in a car accident case. You get damages, that's remedial.
How are you defining equity?
Well, I'm going by the case law from this court and other Maine courts that have interpreted this particular constitutional right to civil jury trial.
And how are you defining what is equity?
Sure. Primarily, you look to the relief sought, and the relief sought here is simply suspension of the license.
Well, here, what he's seeking is declaratory relief, correct? I mean, he wants a declaration.
He did not seek declaratory
It's an
relief.
ADC, and in an ADC, you're not asking for damages, you can't. You're asking for a ruling from the court declaring that his license should not have been suspended, correct?
He is, my understanding is that he is asking that the agency be found to have committed legal error, and he's asking for an instruction to the agency to reverse its decision and reinstate his license.
Right, so we could call it declaratory or injunctive.
I think it's more in the nature of injunctive relief.
Well, there is law that says that if you get declaratory relief for an agency saying, please do that, you don't need to have an injunction because we expect the government to listen to our order that we declare.
That-
So this is, if we go to declaratory relief, it's pretty clear that there are cases in which you get a right to a jury when you are only seeking declaratory relief. Under the Declaratory Judgment Act, if you ask for an interpretation of a contract, you don't get damages, you get a declaration. But the Declaratory Judgment Act points out that if you got a jury in a breach of contract case, you get a jury. So you get a jury when it, even depending on what the case is, going back similarly to 1820 to see whether you didn't get a jury. Isn't that correct?
So what he asked for is that the agency be ordered to reinstate his license. I would suggest that that is injunctive relief. The petitioner did not.
Do you lose if we say that's not really in the nature of injunctive relief?
No, I don't think we lose because first of all, the record here is very thin on the historical analysis because of the way the petitioner brought this case. It's an
Let me ask you
ADC.
about that, because
Yes.
there's been some discussion about whose burden
Yes.
it is. But isn't that really a legal question as to how a particular cause of action was treated in 1820? Burden suggests that it's sort of an evidentiary question, and it seems odd to me that we would make a decision about whether a particular cause of action has a right to a jury trial under the Constitution based on whether there was sufficient evidence on the record pertaining to the history.
Well, I wouldn't think Your Honors would want to make a decision that could affect all of these other trades, as Attorney Walsh said, based on the very thin record that we have in this case. If this court thought a historical analysis was necessary, the department's primary position is.
I guess my question is,
Yes.
can we do that historical analysis as a matter of law? Or your position is that it would need to be, if we thought that that was the analysis that needs to be done, your position is we need to remand it to allow the trial court to do that?
Thank you for clarifying that. Yes, I think ultimately, if this court thought a historical analysis of the situation before 1820 was absolutely necessary in order to decide this case, I don't think the record is robust enough on that issue.
But what we're asking for is a legislative history, a meaning of the constitutional provision. Isn't that an analysis of the law? And we can do legislative histories,
Sure,
can't we?
you can do legislative history, but I think if you look at the cases where they have done a deep dive into what was the historical situation before 1820, it might involve more than just looking at legislative history.
We've done some pretty big dives, haven't we?
Yeah, right, and the record in this case doesn't have that kind of information because of.
But whose burden would it be? And was that burden carried here?
So-
And if it wasn't carried here, what's the result?
So in this case, where the petitioner was faced with an agency decision, he challenged the legality of the agency's decision. The burden is on the petitioner to prove that the agency committed an error
So
of
he
law.
could have, there was no request here for additional facts at the ADC level.
There was not.
correct? There was an opportunity to do that.
He could have done
Was
that.
not requested. Would that have been the place where the record could have been built?
He certainly could have followed that avenue. He could have asked to supplement the record on this issue of a historical analysis if he thought that needed to be proven. He could have done that. He did not. He
Well,
also.
let's talk about burden of proof, because, and you said look at Massachusetts because it comes from the same root. But Massachusetts has a different test for when you get a jury than we do. The test in Massachusetts is like the test in the Seventh Amendment, where there has to be proof that you, in fact, got a jury, and if you can't prove it, then you don't get a jury now. It's the opposite in Maine. You get a jury unless there is shown that you didn't get a jury for that kind of case. So why wouldn't the burden be on somebody who's trying to prove you don't get a right to a jury?
I think in a more complicated case where you've perhaps got a mix of monetary relief and other types of relief, then you might, and if the claim were actually brought properly as a collateral challenge to the constitutionality of the statute, then you might get to that point where that's the playing field now that you're on, and then the burden shifts to the party
Drill down
opposing
on
the
what
right.
You just said that the claim
Yes.
wasn't brought properly, because I'm a little bit confused, frankly, about what's being challenged. There was a jury trial request to the agency.
Right.
The agency can't offer a jury trial.
No.
So is it your view that this wasn't properly presented?
I think the way it was presented and the way it now is before you, the only decision he's really challenging, and he said it earlier today, is the agency's decision not to dismiss its administrative suspension proceeding. He acknowledges that the agency wasn't in a position to provide a civil jury trial, but he alternatively asked the agency to just dismiss the administrative.
Would he have had to ask the Superior Court to essentially provide a jury trial de novo in order to preserve that? Which is the procedure we use in a lot of other instances.
And he did not ask the Superior Court to provide a jury trial
Or
de novo.
perhaps the way to get that jury would be by filing a writ for mandamus, and if that's what you do, and if the counterpart action in 1820 was a writ, and you didn't get a jury for writs, you win, don't you?
Yeah, I think all roads lead to the state winning this case, frankly, because that's absolutely right. Even if he had set all of this up properly and gotten to the point where he could say, okay, I want a jury trial from the Superior Court, he's not entitled to that on a license suspension.
Can you talk just briefly about whether an administrative license suspension for a finite period of time is a controversy concerning property?
I think that's kind of a red herring, frankly, not to use a fishing pun, but
Well, that's the language of the Constitution.
but it is. But whether it's a civil case, whether it's we're assuming arguendo that he has a property right. We're not conceding that for purposes of a procedural due process claim, but there isn't a procedural due process claim, as you've noted here. So we're just assuming arguendo that he has a property
But what are we
right.
to make out for the language in the Constitution that it says, or in all controversies concerning?
Right, and then it goes on to say, except where, and I don't have it in front of me, but where historically the right wasn't provided. Historically,
But isn't
the,
that the
Oh, it's
tipping point?
the other way around.
If we
Oh,
decide
okay.
that it's not a controversy concerning property, boom, door's closed. If we decide that it is, then that door is open, at least to walk through, so.
Unless it's a civil suit, right?
right. So, yes, I didn't argue that initial step, Justice Meade. But if you want to go down that road and say the door's closed to a jury trial right up front, that's fine with me. But I felt that was really confusing the issue, because the issue really is he entitled to a civil jury trial? And I think history, tradition, case law all says that for an administrative license suspension alone, especially here where there's no monetary component of any kind, the answer is no.
The department does have other regulations. They do impose fines for violation. If there were a fine involved here, would your position be different?
So I think the fines actually do not get imposed by the department. Those come into play if there's a criminal conviction or a civil adjudication in court, and that's where the fines are assessed. I don't believe there's a situation where the department
he
does it
gets a jury
directly.
for
But,
that, correct?
but to answer your question, if there were a fine component, no, not necessarily, because then you look at the cases like Falmouth v. Town of Long and Emerson, the DEP versus Emerson. There was
Well, that case isn't in
huge
front of
fine.
us, right? We don't have that case in front of us
No,
now.
but that case held that where there were ancillary civil penalties, it didn't change the fact that the equitable action was essentially equitable in nature, and there was no right to jury trial.
If we accepted the appellant's position here, that would constitute a sea change for practice for both the executive branch and the judicial branch, wouldn't it?
Oh, absolutely.
I mean, it would decades of history where people simply went the ADB or ADC route would be down the drain. There'd be a massive influx. of
I would be very concerned about that, yes.
That's what happened in Jarkissi, isn't it?
I'm not sure if that's what will be the result in Jarkissi, because Jarkissi was focused on the SEC's imposition of a significant civil penalty. So I think we'll see what the effect of Jarkissi is. It may be quite significant. But again, that's the Seventh Amendment, and that's different from our situation here.
If anything, it's narrower. And ours is
Arguably.
broader.
Yes.
You are probably entitled to a jury trial in more cases in Maine than you would be in the federal system.
Perhaps, perhaps. But again, you know, I thought Justice Collins' statement in dissent in Soroas v. Winslow was very interesting, and Justice Collins quoted the Petrocelli and McKay article that is in the record, saying this can't mean that administrative license suspensions entitle people to a civil jury trial. It just can't mean that. And I think they're absolutely right.
Well, our first step in analyzing a constitutional question is looking at the constitutional text, correct? And we go where that leads us, correct?
I think you have to look at the constitutional text, absolutely, but I think you also have to look at the significant body of case law interpreting that text. Thank you.
Thank you. Attorney Walsh.
I think I just heard that the Constitution of the state of Maine was overruled. There's a couple of things. This is a 3-year license suspension. A 3-year license suspension is not remedial to a lobsterman. It drives that lobsterman out of his or her livelihood for all time. You can't recover your bottom after 3 years of being off that bottom. In many cases, it's been my experience, destroys their lives. They file Chapter 7. They are often getting divorced. It's a crushing suspension. DMR knows it's a crushing suspension, and that's what it's intended to be. It's intended to be a punishment. Most of my clients would happily pay a $100,000 fine rather than have a 3-year license suspension. It's a crushing punishment. The presence or absence of a monetary penalty is, per the town of Falmouth case, really, it's just part of the analysis. It's not the whole thing. We have to look at the big picture. What is the sanction imposed? Here, we have a 3-year license suspension. Huge. I just want to touch briefly, I don't know how important it is really at the end of the day, but the Massachusetts case on which DMR to some extent relies, Dougherty versus Retirement Board of Medford, has buried within it an extraordinary fact, which I think turned perhaps the court's opinion, they reference it, which was that in the underlying case, which led this murderous, corrupt Massachusetts cop to lose his retirement benefits, for whatever reason, in the administrative hearing before the retirement board, the officer's lawyer saw fit to include the entire transcript of the federal criminal jury trial in the evidence.
Counsel,
And
can I turn you to a different point
Yes.
then? Procedurally, you asked for a jury trial in front of the Department of Marine Resources hearing officer. They said no. A, it's not in their regulations, and they don't actually ordinarily decide constitutional issues. And B, as a practical matter, there's no way of that happening at that
Yeah.
level, correct?
correct, that's why we asked for an alternative.
Well, okay, so what you did is you filed essentially an appeal to the Superior Court under Rule 80C. Did you ask for a jury trial de novo in the Superior Court?
Well, as I said, there are a number of matters pending before the district court right now, which is one reason why
I
this.
understand there's also
Well,
criminal
in,
matters.
in one of those matters, in those matters, Mr. Anderson elected a jury trial so that it would parallel the procedure that was in
I
place
understand,
before
but that's not
2017.
this case. That is a separate case. And how did you perfect, if you will, a request for a jury in this case? I mean, what you did was you appealed under the Administrative Procedures Act and under the Rule 80C to the Superior Court, upon which the review is simply for errors of law. And you've essentially conceded that as far as having the hearing officer conduct a jury trial, that there's no error there.
So what we asked for in that motion was an order either dismissing or staying the administrative action until the district court, and in fact the Superior Court, because he'd elected a jury trial, had done its
You call it
work
the Unified Criminal Court.
in the criminal court. But I mean, what I was doing is saying, look, this is how it was done before 2017. That's how it should be done now. That's the constitutionally correct way to do it.
Thank you, counsel.
Thank you.
As is our usual practice, we will be taking this matter under advisement and issuing a written decision in due course. And with that, we'll be in recess on this matter.
All rise.
Good morning, you can be seated. I can tell the students keep changing because the room is a lot more full now than it was for the last argument. So I know there's been some change. Good morning, I'm Chief Justice Stanfield of the Maine Supreme Judicial Court. We are very happy to be here. We like going out to the schools and seeing all of you. We hope that at least some of you think this is at least somewhat interesting as well. As I say, I'm the Chief Justice of the Maine Supreme Judicial Court. My chambers are in, which means my office, that's what our chambers, is in Augusta. Before I was put on the Maine Supreme Judicial Court and nominated by the governor to be chief, I was a trial judge for many years as well. What I'm going to do is turn to my colleagues, and we always, by ritual, go in order of seniority, meaning seniority on the court system, not how old we are. So turning to the Senior Associate Justice.
Thank you, Chief. My name is Andrew Mead. I'm the Senior Associate Justice. I've been a judge for 35 years. Served on the District Court and the Superior Court for the last 18 years on the Supreme Judicial Court. My chambers are in Bangor. We ordinarily hold our oral arguments in Portland, Augusta, or Bangor, but this is always a special time for us. It's great to be out here. We survived the monsoon to get here. Great to be here. Thank you.
I'm Catherine Connors. I have been on the bench since February 2020. My chamber is in Portland, and I live in York County.
Good morning, I'm Rick Lawrence, and I have been on the bench for 25 years, 22 of that in the District Court here in Maine, and I came on the Supreme Court in May of 2022. And my chambers are in Portland, and I reside in Cumberland County as well. And very happy to be here.
Yes, good morning. I'm Wayne Douglas. Thank you for having us. I have had the privilege of serving on the courts, trial courts, and this court for a little over 20 years. Been on this court for about 2.5 years. Again, thanks for having us.
And good morning. My name is Julia Lopez. I'm the most junior justice. I'm relatively new. I've been on the court for about 6 months now. I previously was on the trial courts, on the Superior Court, and my office is in Portland. And it's wonderful to see you all.
And I have earlier today welcomed many of our, I'll call them celebrities, such as Representative Greenwood, but I think we've been joined by another member of the school board, am I correct? Yes. Okay, thank you. And is it Ms. Medor? Thank you. Thank you for having us here today. I will now then move to the case that's in front of us and call that case. The matter that is before the court now, number here, is Waldo 2577, State of Maine versus Alan James Jr. I see counsel are present. I'm assuming ready to proceed. If you want to introduce yourselves by saying your names for the record together with the party that you represent, starting with the appellant.
Good morning. Rory McNamara for the appellant, Alan James Jr.
Good morning. Assistant Attorney General Jeff Baruti for the state of Maine.
Thank you. And I will note that we are being recorded by both video and audio for the web. And Attorney McNamara, if you're ready to proceed, we'd be happy to hear your arguments. I'm told I should remind everybody to do what I wasn't just doing, which is to make sure you stay close to the microphone.
Thank you for that reminder. May it please the court, Attorney Baruti. Maine's accomplice liabilities.
Closer to the microphone.
All right. Need many reminders. I
can
apologize.
hear you because you're a short distance away, but we want to make sure everybody in the room can hear.
Maine's accomplice liability statute is already expansive, even when properly
Counsel,
instructed.
Since, you were brave enough to allow the green light to be on right from the beginning. Let's talk about the instruction in this case. So the judge gave an instruction with regard to accomplice liability, correct?
Correct.
And your concern is that In the instruction, he refers to having the intent of promoting or facilitating the commission of a crime, and the person, aids, agrees to aid, attempts to aid another person who commits a crime, and that would allow the jury to find any crime, not necessarily the crime.
That's one of the categories of error, yes.
But the prior sentence is, the case is all about the specific crime of unlawful trafficking and conspiracy. And the sentence before says, you can be guilty of a crime if you personally do the acts that constitute the crime, in which case the person is guilty of the crime as a principal. The second way in which a person can be guilty of a crime is as an accomplice to another person who actually commits the crime. And then it goes on to say, this is what we're talking about. Is there really any reasonable possibility that the jury would say, well, he's an accomplice to somebody, to people who were committing a crime other than trafficking, and therefore I'm going to find him guilty as an accomplice to trafficking?
Well, I think there are 2 or 3 components to that. The first is just the general statement that that description, a person may be guilty of a crime if, is explaining what can happen, not how it can happen. The following sentences explain how it can happen, and that's where the material defect comes up. Second, and probably more importantly, this case is not just about the possibility of committing of a determination of a jury findings based off these instructions, based off of other offenses. Perhaps more concerning, it's about the possibility that jurors were able to take a mens rea from here, an actus reus from a different incident. It's a lot.
That's a big deal because
Right.
accomplice liability, as we know, sometimes it takes people by surprise to realize you don't actually have to commit the crime, but if you assisted, if you facilitated, if you were a driver, you can be convicted of that very same crime. So we need to be very careful about the language.
Right.
And in this case, there's a jury trial. The judge is explaining to the jury what would satisfy the accomplice liability definition. And he did, ordinarily you're talking about the one crime. So if it's bank robbery, whether or not you facilitated the bank robbery, but by not saying that crime, he's saying a crime. It could have been a situation, far-fetched, but let's say the person committed shoplifting or something shortly before
Sure.
the bank robbery. They said, but he didn't assist with the bank robbery, so they could find him guilty under that interpretation. I'll suggest 2 things.
Yeah.
One, I think that's a bit strained because, as the chief said, we're all talking about the actual crime here. But the judge also provided the jury with written jury instructions that gets it right. You don't disagree with that, right?
Well, it gets that part right? No, I do disagree with that. As to the presence instruction, this is the second category of error with the accomplice liability instruction. That was erroneous in the written instructions, the presence definition. Erroneous in the oral instructions, excuse me.
It was correct in
Thank
the
you.
written instructions.
Correct in the written, yes.
But when giving the oral instruction, the judge probably misspoke.
Right.
Or may have been mistranscribed, we never really know which it is, engaged in any conduct, however slight, or promotes or facilitates the commission of the conduct. And it probably should have said, engaged in any conduct, no matter, however slight, or that promotes or facilitates the commission of the crime.
Yes, and I think it's important in regards to the presence instruction to know that obviously when jurors go into the deliberations room and to make a decision, they do not necessarily look at those written instructions.
But we assume they do. There's
Oh,
no
I don't-
reason, why should we assume that they don't look at the written instructions any more than we assume that they will listen to the, that they're going to abide by the oral instructions? Why should we treat those differently?
Well, we
don't.
absolutely know that they heard the oral instructions. They were there
We don't
for
know
that.
actually. I find people sometimes don't hear many things.
This court presumes that they
Right.
have
So why
heard
should
in
we
the
presume
courtroom.
that they also review the written instructions?
Well, I think that's one thing. There's, as the court in Maryland said, I quoted this in the reply brief, we're pointed to nothing in the record that shows that the jury has consulted with those, let alone took notice of this particular fact about the
But
instruction
isn't
in
that
that case.
particular instructions about presence actually, in some ways, a bit superfluous, because the whole point is that Mr. Allen actually wasn't present at these transactions.
Well, I think it depends on what you mean by presence. He resided in the home. There's no
Wasn't in
question
the
about
room,
that.
Wasn't actually there at the time.
Well, I
is
think
what mean.
that, for lack of a better term, I think that the state or jurors would assume something called constructive presence, in the sense that that's his bedroom. Those are materials there. Going back to Justice Mead's question, this is not a hypothetical about shoplifting, for example. We know that there were other crimes here, and that's documented at page 24 of the blue brief, that were uncharged. There was certainly possession of drugs. I don't think there's any dispute about that. There's arguably furnishing of drugs. There's maintaining a drug-involved premises. There are several things here that were not charged. In fact, the state even pointed to some of those in its closing argument. But again, I go back to it not being a vital component of my theory of prejudice here to say that it must be based off of uncharged crime. It is the possibility that they took a mens rea from the August 4th incident, mental state of mind and intent, and cobbled that together with a physical act, an act of helping, and those are the two components of accomplice liability, from another date, from the April 25th date, or the 7th of July, or the 5th of July, or...
What I hear you doing is saying, it could have, but what we do when we review instructions is we look at the instructions as a whole, right?
Correct, and we have...
Don't parse out whether one word was wrong, even if it is wrong. We
Right.
look at the instructions as a whole.
That's correct, and we have multiple errors here. That's why I've mentioned both the presence component, the A and the component, the improper, unfortunately, definition that the prosecutor gave in opening statement that mentioned no criminal intent whatsoever. I think those all go together, and what's very important, I probably wouldn't be here making this claim if we didn't have an acquittal on one of those three counts, if we didn't have a hung jury on two other counts, saying in that jury room there was a lot of debate and a lot of uncertainty about the state's case.
Can I just ask you, you don't have a lot of time left, one more question on this, because I'm sure there'll be questions about the sentencing. But in this case, the parties saw the written instructions, the lawyers heard the instructions, they were offered opportunity to offer corrections, additions, and so on. And they said, oh, we're good with it.
The state has conceded that the appropriate error is here as if there was a possibility of confusion, as if it was preserved, and prejudice. So I disagree. There was objections on the record,
Well, what was
missing parts of them, but the state has conceded
Wasn't
the prosecutor was there.
Hold on. Wasn't the objection to giving an accomplice liability instruction at all?
Correct. That
Not
was
to the content or the phraseology of it.
we
And there
don't-
was certainly no request after the instructions were given to correct anything.
there was an objection on the record that is unintelligible, and unfortunately.
Whose burden is it to try to recreate the record? If you want us
Right.
to determine whether something was preserved,
I
don't
think-
our rules allow you to try to do something to reconstruct that?
They-
And you didn't do that here?
They do. No, we didn't. But the state has conceded that this was a preserved error. So I don't feel as if it's a burden upon, because that's certainly a forfeiture of any different standard of review. It would have been incumbent certainly in a post-conviction review setting for me to go back and do that. And that's really what the difficulty of doing that is on a direct appeal in a criminal case where there's an adversarial proceeding coming up next for an attorney like me to do the investigation that normally should be done in post-conviction review. So in these circumstances, I relied on the state. I said, I'm not sure which standard of review should be used here. They said it's preserved. That's what we have here,
Can I take you back to
consequentially.
your argument real quick, though?
Yes.
To the extent that you're suggesting that they may have picked the mens rea here and an actus reus there,
Right.
doesn't the fact that, as you pointed out, they were deadlocked on a couple of counts and they actually acquitted, doesn't that suggest that they worked very hard to work through to come to a resolution as to what they all agreed on?
I think it indicates that there was stronger evidence as to one count. But also sometimes jurors compromise on verdicts. I
But
hearken
counsel,
to...
It's dangerous to try to interpret a a jury's verdict, right? I mean, it could be interpreted the way you want us to interpret it, which is that these jury instructions really misled them. Or
Right.
it could be interpreted the other way, as Justice Lawrence was suggesting, which is that they understood their obligation and worked through it carefully. I mean, can we really deduce anything from a
Right.
split verdict?
Well, I think it's built into the standard of review for a jury instruction, whether there's a potential for misunderstanding. I've cited several cases from Washington State where they have said, absolutely, jurors, there's a potential for juror misunderstanding in these cases.
Can
I don't see how
move
Maine
you
would
to
be.
the other issue in this
Sure,
case, which
yes.
is the sentencing? We have very little time left. Can you articulate what your argument is? Is it really that they used, that the judge used some conduct
Right.
to aggravate? I mean, can you articulate your
This issue is before the court in a sentencing appeal.
I know.
We're discussing the propriety rather than legality. It weakens the Sixth Amendment at the knees, the right to a jury trial, to remove, at the time when jury instructions should be given down, the language of the indictment to say, let's find a course of conduct, and to say that is
But wasn't
surplusage.
I'm going to stop you on that. Is that, if that's your issue, I mean, wasn't there plenty of evidence of essentially uncharged conduct too? I mean, there was a stack this high of Facebook and text messages.
Right.
For many days beyond the days that were charged.
Right, I'm not here arguing that there was insufficient evidence of other things, certainly at a preponderant standard. And that's really the concern, is that it doesn't look good, it doesn't feel good.
I want you to finish your answer.
Thank you. And there is a lack of notice coming into a sentencing hearing when the judge has said, that's surplusage, for the judge to then turn around and say, I'm increasing your sentence because of what I found to be surplusage earlier.
All right, thank you.
Thank you.
Attorney Baruti?
Thank you. May it please the court. Alan James was the only source of drugs sold out of a residence in Jackson, and the money generated from those sales went to him. The drug trafficking operation that ran through the house was his. He controlled it, and he profited from it. Therefore, the trial court's accomplice liability instruction was accurate, and when reviewed in the context of the complete jury instructions and the evidence admitted at trial, properly instructed the jury. James contends that the court's use of a rather than the in describing the subject crime of accomplice liability is reversible error. However, the accomplice liability instruction referred to the crime, both before and after its reference to a crime, and the references to the crime outweighed those to a crime. When this court reviews the jury instructions as a whole, it cannot find prejudicial error in the court's limited reference to a crime. The Washington cases that James leans on to support reversal do not mandate reversal, and in fact, many of the Washington cases in which this issue arose were not reversed. Washington versus Roberts held that general knowledge of the crime was sufficient, and that knowledge by the accomplice that the principal intends to commit a crime does not impose strict liability. Washington versus Carter held the substitution for a and the did not require reversal because it was clearly evident the defendant was convicted as an accomplice based on his knowledge of the crime charged. And Washington versus Zagier was upheld because the state proved the defendant had actual knowledge that his conduct would promote or facilitate the crime for which he was eventually charged, and that to be convicted, the individual must have acted with knowledge they were promoting or facilitating the crime for which they were charged, not merely knowledge that they intended to commit a crime, or the principal did. So in sum, these Washington cases apply a fact-specific analysis of the A versus Z substitution, and then only reverse a case when evidence of uncharged conduct is admitted and when prosecutors refer to that in their arguments to the jury. Here, the defendant acted. In this case, there's overwhelming evidence that he was trafficking in drugs and that he knew he was promoting the crimes of drug trafficking. It's also the state's position that the court's reference to the commission of the conduct, however slight, did not rise to level of obvious error. The state contends that was not a preserved objection, and therefore the court has to look at that with the obvious error standard of review. And then again, when reviewed in the overall context of the jury instructions and as well with the written instructions being proper, that is not reversible error. And then finally, the court committed no error in setting James's basic sentence. The court merged counts 2 and 5. 5 alleged the whole summer from April to August, and the court considered the evidence of trafficking admitted during the trial of all of that time period. So by then appropriately emphasizing the nature and seriousness of the conduct, not the volume of the counts charged or the crimes charged, the court was proper in setting its basic sentence.
I saw Attorney McNamara make quite a face when you said something was not preserved. But regardless, is that with regard to the accomplice instruction, I mean, isn't this really basically on all fours with State versus Plummer, in which apparently I gave the same instruction since I was the trial judge in that case?
I'm embarrassed to say that I don't know that one off the top of my head, Your Honor. I'm sorry. I wish I did. It sounds very relevant.
It was okay.
Yeah, I can't believe I missed that. I'm sorry, Your Honor.
Okay.
I'm a little confused about the sentence.
Okay.
Can you go through it a little more? It's looking like double counting to me, so can you go through it a little more slowly for me?
Sure, in terms of how the court set the basic
We
sentence?
start with identifying, well, there was a merger of 2 counts.
There
right?
was, yep.
And we know that 2 of the dates, the jury didn't find he was not convicted of those 2, correct?
In one, he was acquitted. The other, the jury was hung, yes.
Okay, so there is no jury finding of more than one of those sales occurring within the range of that date, correct? There's count 2, that's a specific date of the one that the jury found he was guilty of. And then there's count 5, that's the range, and those got merged, right?
They got merged for the purpose of sentencing.
Okay.
The state believes the jury could have found that the CI buy on the single date was one basis for trafficking liability, and with all of the ample text messages, Facebook, and Olivia's testimony as well, the state believes that the jury could have independently found that he had been trafficking through that whole time. And so I think it is a little bit speculative to say that the jury had to have found him for the range of the dates if they only found him guilty of the one date.
So they could have, so the sentence could see a difference, even though it merged those, for purposes of finding what the basic sentence should be? This is where I get lost.
So for the purpose of the basic sentence, the state believes the court did it right by merging them to avoid any double jeopardy issues with
Right.
the 2 conduct, because they were within the same crime within the same range of dates ultimately. So for that, the state believed that merger was appropriate.
Okay. Well, then why wouldn't you just treat it as one, when you're looking at the sentence for the
Yeah.
basic, then you can look at it beyond that one sale?
And I think the court did, and I think we can.
Okay.
Swallow your mic. I don't know that his is working. Can anybody hear him?
Anybody hear me? I'll just speak up loud.
Outside voice.
For purposes of, as I read the sentencing transcript, the sentencing judge seemed to say that the conduct as a whole, if he were considering this as a Class B offense, then the basic sentence would be in the range of 6 to 7 years. But this is a Class A offense, so therefore I'm going to multiply times 3, because a Class A offense, the maximum is 30 years, and a Class B offense, the maximum is 10 years. But we're talking about the same conduct. He's made an assessment of the conduct and said, you know, if this were a Class B, it'd be 6 to 7 years at the base value. But it's an A. It's not a triple. Is that an appropriate analysis?
I believe it is, Your Honor, because he was looking at the crime in the context of how the legislature classified the aggravated crime by increasing the maximum sentence. It is the same conduct, but viewed through the prism of an entirely separate charge in a different statute.
You're saying that because a Class B, the maximum penalty is 10 years. If it's a Class B and you find it's maybe a little above the mid-range, i.e. 6 or 7 years, then because the maximum penalty for a Class A is 30 years, you locate it in the same place. Is what the judge was doing? He could
I think so.
locate it in the same place by tripling it. It's still just slightly above the mid-range for the basic sentence of 18 to 21.
I think so, because as the court's well aware, as the trial court does the sentencing, it has to determine, where this falls on the
But
most
does
benign.
that make sense if it's the same conduct?
I think it does, because the legislature has classified this differently. The legislature
Well, they
is.
classified it differently as a result in this case of, there are other bases, but in this case, it was really the prior, right?
Yep. Yes, and the legislature's goal is to deter traffickers by increasing the penalties for people who have prior convictions from the very basic analysis of the basic sentence.
As you know, we've set out a three-step process for sentencing. Sometimes it's confusing even to lawyers. The first step requires coming up with a basic sentence that is derived from looking at the four corners of what the person did. Just looking at that in a nutshell. And if it's a crime, if it's an assault, if it's particularly brutal or disregard for human life, those factors go into that first step. It's unique to the event itself.
Swallow your mic.
Go with handheld. I might swing
He
into
is our
song,
musician. He
which is a
might
bad
do that.
idea. If I swing into feelings, just whack me in the head. But in the second step is where you look at the circumstances that are unique to the person themselves. Like if this is part of a course of conduct they've been doing for years and so on, that's where it comes in. But we're finding instances where judges in the first step are looking at, wow, this person's engaged in this kind of conduct, and then they put the same factor in for the second step. I don't know if that happened here or not. Do you wish to comment about the scope of the judge's imposition of the sentences at both step 1 and step 2?
Yes, thank you. I think that a fact could be used at different points as long as the court is articulating the reason why it is using those facts. I would say that in this case, on the basic sentence, the existence of the prior conviction made it a Class A offense. The court did a pretty significant description of the nature and seriousness of the case here, and didn't at all rely on the defendant's prior criminal history to set the basic sentence, only that it put
Can I
the
interrupt
case.
you for a
Yeah.
second? The indictment alleged a period of range, so that he might have done stuff within that range. As long as he did, it's still the offense itself, but he may have engaged in multiple offenses during that period. Can that be considered at step 1?
Absolutely, it can. The jury found him guilty of trafficking during that range, yes. So any conduct that occurred during that period from April to August, the state believes is fair game for the nature and
So that's been factored in
seriousness.
step 1. And then if you go to step 2 and say, well, this person is a drug dealer, trafficker, multiple opportunities, it's an aggravating circumstance, can it get bumped up again?
It absolutely can, because in step 2, the court will be looking at the defendant's criminal history.
But it has to be used, again, State versus Plummer, on the sentencing appeal, it has to be used for different purposes if you use the same factor at different stages.
Exactly. And so as long as the court articulates that appropriately and it's clear what the court's doing, the state believes that's permissible.
On your jury instruction, or on the jury instruction issue, going back to that, can you clarify for me what you believe is preserved and is not preserved? Because I thought Attorney McNamara suggested that he read your brief, I guess, to concede that the entire, both of his jury instruction arguments are preserved, and I think you said something different.
So, yes, the state believes that the inclusion of the accomplice liability instruction was a preserved error. I think it's not clear in the transcript, but from being the trial attorney
To give an
present
accomplice
there.
liability
Yes, to give the
instruction at
accomplice
all
liability,
is
yes.
preserved.
The state believes that the essentially the court's misreading of the written instruction was not preserved, that was not objected to. And then the other issue about the content of the accomplice liability instruction, I didn't argue that wasn't preserved, but I think that the transcript would show that the only actually preserved error would have been the actual inclusion of it. Nobody really contended that the way it was written was incorrect.
So you think that we should be reviewing the arguments that Attorney McNamara has made for obvious error?
Do you think it matters?
Well, so that was what I was going to say. I mean, I think that the state would appreciate that, but at the end of the day, it doesn't matter to the state when the court looks at the facts of the case and the whole jury instructions. The state believes that it's not error.
Thank you, counsel. There don't appear to be additional questions.
Thank you.
Thank you, and I do apologize for my awkward look, Attorney Baruti. Sorry about that.
It was quite expressive, Attorney McNamara.
It was. Page 16 and 17 is where there is a concession of sorts of the red brief that is acting as if this issue is preserved. I do acknowledge that on page 22, as it regards to the presence component, the component about erroneous presence instruction, that is to be reviewed for obvious error. I think we can consolidate the terms of prejudice, and I don't think there's any question that the instruction is erroneous. It is not the language of the statute. 17A MRS 57.3 says very clearly, the crime. And in terms of prejudice, and the fact that this is, well, I don't want to talk about prejudice quite yet, about the conception that this is something that is susceptible to misunderstanding, because that is a component of the standard of review for a preserved instructional error.
Why is it different here than it was in Plummer, where the same instruction was discussed on appeal?
So I argued Plummer, and I thought this was the first time this has ever been argued, so I don't believe that issue was argued. Certainly it wasn't preserved if it was in the manner that the state has conceded here.
There are two Plummer appeals, but
Okay.
there's a sentencing and there's also an appeal of the trial, and that instruction was explicitly discussed.
If that was the case, Plummer was wrongly decided. I mean, the statute is very plain, and we have persuasive case law from, I realize it's a foreign jurisdiction, but it's actually a foreign jurisdiction with a less stringent accomplice liability standard, where knowing conduct rather than intentional in Maine will do. I think it would be a poor statement for Maine to say this is tolerable here, where other states are not tolerating this, and in fact recognizes
But the
this
problem,
is error.
and I'm going to go back to it, the problem is we don't look at instructions in isolation. We look at them as a whole. And,
Well-
I mean, we can agree with you, or could agree with you, that saying A instead of the crime in isolation is not good, and we could even say that. But we look at it at the whole, and whether it fairly informed the jury of what they needed to do.
Right, and I think there were multiple components to that error here that we do look at, the presence component being one of them, but also think of this as analogous to specific unanimity instructions, where jurors can take different incidents and cobble them together. That's what's happening here.
Specific unanimity road.
Well, I want to mention the fact that this court also has, think about specific unanimity, where it's been 10 plus years trying to get trial courts to give the instruction as a matter of course, certainly when it's needed. As a matter of supervisory authority, we are now decades on perpetuating an error that is clearly plain in the jury instruction manual.
If there's an authoritative treatise that has like a standard instruction, it might not be right. Does the lawyer have the obligation to ferret out that treatise's direction?
Go ahead.
Thank you. I think as to the state's concession, 16 and 17 of the red brief, this court should treat it as if that did happen in this case. Thank you.
Thank you, counsel. As is our usual practice, we don't give you our decision now. We take this matter under advisement and issue a written decision in due course, and we will do that in this case. And with that, we will be in recess on this case and here at the high school. Thank you for having us here this morning.
Jeff, sorry about my askance look.
I didn't even
I
notice
think
it.
I misheard you.
This is one of those situations where had the judge not said anything, I would have never known.
This group has questions too.
Yeah, we'll have some dinner table discussions about it too.
All right, we'll take a couple questions now for the